your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting has some homework for you and he's got some advice for you as well. 1300 222 774 if you'd like some help today. David Whiting, good morning.
Good morning, Virginia.
What was the homework we left you with?
AJ from Mentone ringing on behalf of a son who started work for an organisation before the pandemic, and whether it's part-time or full-time, I'm not sure, but he works in retail. He's now been told that he's to be sent to a store which is 30 kilometres away.
That's right.
Which is an extraordinarily long way for a placement. And I know that you told me that that's in your contract. But
they can send me anywhere.
Okay. But there is a provision.
They may well.
There's the concept of undue hardship. So
yes, that's what I'd be arguing.
Yeah, absolutely, right. But if it's undue hardship, then you're entitled to seek a review of the decision. And if it's undue hardship, what you might end up with is an argument for constructive redundancy or constructive dismissal on the basis that, particularly if, say, you catch public transport and you were a walk from this store and you're 2.5 hours from that store, that's where the argument goes from AJ's perspective.
And is that going to be a hard case to prosecute if he decides to go down that path?
It's a Fair Work claim, so you might talk to the Fair Work Ombudsman. The question would be, sort of how old are you, how are you going to get there, how much extra money is it going to cost to achieve the outcome? It might be another 3 or 4 hours out of that person's day.
Yeah, absolutely.
Yeah.
Okay. Hope that's helpful, and we hope we can be helpful now. 1300 222 774. Doris in Taylors Lakes. Go ahead, Doris. Good morning.
Good morning. Good morning, Mr. Whiting. We've got a rental property, and we had from the storm, we had a leak in the bedroom and in the lounge room, and we got this guy to come out and have a look at it, and he quoted us $9,000 for it.
Yes.
Yeah, and anyhow, in the meantime, we went and had a look, and he didn't do the job as what he said he was going to do.
So it's not done to the standard that you want?
Yes, correct. And so we stopped it. We stopped it from that because they cut out.
If this was a quiz, that would be called your brains trust, wouldn't it, Doris?
That's right.
Yes. Okay.
Coaching from the sides. Yes, go on, Doris.
Yeah, and anyhow, we stopped him because with the $9,000, he was going to paint and everything else. So we stopped him there. We only ended up giving him $4,500.
Yes.
Now, can we do anything about that, or?
Well, the real question you've got. I mean, let's. I suppose there's two parts to this. You've agreed that he would be paid $9,000 to do a particular job to a particular standard. You haven't finished the job yet.
No, he hasn't finished.
No, you've fired him.
Yes, that's
correct. But the job isn't finished. So what you need to do is go and get someone to complete the job.
Okay. Yes.
And then work out whether it's you owe him some more money or whether or not he owes you some money.
All right. Okay.
All right? So you need to get the job finished before you can take the next argument, Doris.
Okay. All right then. All right. Thanks, Mr. Whiting.
Thank you.
And also just get the job finished so that the property is protected and not exposed.
Yes, well, it's a rental property, so your tenant wants to make... Yeah,
exactly,
absolutely.
Yeah,
yes.
yeah.
Fix the roof.
This is a sideline, but it is a conversation that's coming up again and again, particularly right now when we're talking about rentals, the high cost of rentals, the responsibility of landlords, and you and I have gone over this. The resistance that we sometimes hear from people when they get a bill for $9,000 for fixing a leak in the roof. It's as if some people who buy investment properties don't expect that it's going to cost them money to maintain a property that might be worth $300,000.
Or $1 million,
or even more, exactly.
Yes.
If you buy that kind of property, you've surely got to expect
that
in order to maintain
it. Standard.
Well, exactly, yes. But also just to protect your investment.
Yes.
Yep. It's going to cost to maintain it.
Yes.
This seems to constantly come as a surprise to people, David.
Well, no, it's I'm now I'm a tenant in your house, I have to expect lower standards now. That's the expectation is that you'll put somebody in and they won't complain because the property doesn't measure up.
I also don't understand why, as the person who owns the home, it wouldn't bother you, it wouldn't immediately freak you out. There's a leak in my roof. It is a roof in the house that I own, and it is damaging that house right now. I am very concerned about that.
I'm not suggesting from a sympathy perspective, but the impact of land tax on rental properties has just been extraordinary.
Yes, I think it's true.
I see clients who are selling properties because the net return of the property is so close to zero because of their land tax bill.
Yep, I accept that. Ross in Mansfield, go ahead. Good morning.
Hello, Virginia. Hello, David. I've got a property in Mansfield. It's a pine plantation. It's land only, but we do go up there and camp on it because I'm doing maintenance to it. And deer hunters are constantly coming in there, hunting deer, shooting, spotlighting. Is there anything I can do, David, if I catch one of these people? Can I have them charged? Or
you can arrest them and you can take them to the police station, but you can't arrest them and just keep them. All right?
Yeah,
if you find someone committing...
Well,
do you understand that? If you find someone committing an offence, you have a power of arrest, but you've got to take them to the police. And if you take them to the police, I'm not sure how interested the police will be. All right?
Right.
Yeah.
It's also the challenge of taking them to the police.
Oh, absolutely. They're armed and you're not. And Ross, please don't get armed just to protect your property. You might put up signs that say trespassers will be prosecuted. You might look at some camera type arrangements, but then you'll have no power on your property.
Yep. Right.
You have that practical problem.
Yeah.
So I have no brilliant solution. Sorry, Ross.
Thank you.
All right. Sorry, we can't be more help there. Let's hear from Paul in Keysborough. Hi, Paul. Go ahead.
Yeah, hi, David. In 2013, my wife, myself and the mother-in-law built a home with the purpose for her to live downstairs and us to live upstairs. Long story short, she put in half the money and is on the title.
Yes.
The consequence of that at the moment...
Sorry, how old is your mother-in-law?
She is 67.
Okay, yep.
And so currently we're at the point where we want to purchase another home. However, our borrowing capacity is diminished because of the fact that she's on the title. Effectively, we can only borrow
She's
half.
A half owner. Yes?
That's correct. In order... I'm not sure how we can actually remove her off the title, but also safeguard her legal claim to the...
Can I ask, Paul? I mean, I can. There are red flags about your grandmother-in-law's financial position and all the rest of it. But what if your mother-in-law became a 1% owner of your new property? Not a half owner, but a 1% owner, and then you have the same borrowers on both titles.
I'm not sure.
At the moment the issue is because your mother-in-law is not part of your purchase contract, nobody wants to lend you money because you only own half a house. But if the three of you were on title, you don't have to be on equal, or she doesn't need half. You need an agreement to protect her in the scenario. But if she was on to 1%, then she owns 1%, you and your partner own 99%, then what you've done is you've matched the borrowers, the three of you, with the security providers, who are the three of you. And that will, if you can find someone who lends you that money, that will overcome the problem. The difficulty is that since the Royal Commission into the Commonwealth Bank's lending practices, it's actually much harder to borrow in that scenario because your mother-in-law probably has little or no income.
That's correct. She's purely on the pension, and I think that's been the dilemma where we've just had difficulty in finding a lender who would actually even listen to us and sort of see how they can accommodate our scenario.
Well, instead of... There is no easy solution, Paul. That's the one to buy another property. But to me, it's a broader question of how do I protect my mother-in-law?
All right, we'll leave it there and we hope that's helpful to you. Thanks so much for calling in. Chris in Sunshine. Hi, Chris. Go ahead.
My neighbour and I had a new fence built about 3 or 4 months ago. And at the time when the fences built it, it was a contractor arranged by him on his terms, friends of them, in fact. They ran a string line from one end to the other. and it moved it over by probably 60 or 70 mil into his place. Now I'm building a carport in my place, and he's decided that he doesn't like where the fence is, and he's going to get a surveyor to have a look at it. Where do I stand with all that?
Well, how long have you lived there, Chris?
8 years.
All right. Now, you're entitled to have the fence back in the place the fence was.
I am,
now,
he is. I've got some... It's moved towards him, so I've got more.
Well, then I'd be going to the fencer and asking why the fencer moved it. Sometimes they move it because it's more convenient. So your starting proposition would be the fence has been in that place for more than 15 years. Oh, sorry. I'm looking at it from his point of view. He's entitled to get the fence in the right location. You've acquired no rights in the land between the old fence line and the new fence.
Okay, so given that he's arranged the contractor and supervised it all,
yes,
how does that affect it?
He's got an action against the fencer for putting in the wrong spot, as do you, although you quite like its current location. But you don't own the land between the old fence line and the new fence line.
Yeah,
you just
unless
don't.
if it's surveyed, and they come back and say that it's one way or the other.
Well, if the surveyor comes back and says the fence is now on the true line,
there's no problem.
Well, no, you may have lost. If the fence was more than 15 years old, it may be that you've lost your rights to that little strip of fence. But it's really a question for your neighbour, because he's the one who's got the right that needs to be enforced. You have no right to that little strip of land at this point.
Okay. Good on you, Chris.
Worries, thank you.
Thanks so much. Peter in Croydon, I think Peter's had an encounter with one of those big data breaches. Is that right, Peter?
Yes, good morning, Virginia and David. Latitude Financial Services wrote me a letter a couple of months ago saying that they lost essentially my personal information through the cyber attack. Now, I didn't know Latitude existed even.
Did you know a company called GE Finance?
Yes, that's what I'm getting to. I bought it from them.
No, Latitude is GE Finance. So, well, I don't know whether it was a name change or a takeover. I think it was a straight name change.
Yep, it was.
So Latitude has your financial data because they were GE Capital.
Okay, so how long are they allowed or required to store?
That is the terribly interesting question.
That's the question
that the world is struggling with.
Yep.
Right now, I'm quite proud of the fact that I've got client records going back 50 years. But should I have it? When should I unload? Right?
Well, if you have a break-in, right, and someone gets that data, and they've been sitting there for 30 years, you haven't served just a client in 30 years, you're going to have a very angry conversation to have, or they'll be angry with you.
They quite possibly will be. I think that from a client's long-term record keeping, it's better to keep them secure. So that's the question, Peter. One could turn around and say, I only need to keep the records as long. Well, I need to keep it for 2 periods. The first one is the period for which I'm contracted to provide a service.
Yep.
And then beyond that, you might have the right to sue me for something I've done wrongly. And, I would need to keep it for that period as well.
Sure. I mean, this is like...
Can I ask what your question goes to, Peter? Has something happened apart from the breach?
Nothing, but this is the interesting bit. I went to Vic Roads to change my license number, and they flatly refused to do that. They say if you've been notified by an organization that a data breach may have exposed your license details, but no fraud has taken place, Vic Roads will not be able to change your driver license number. So I just have to sit here quietly and wait to get robbed.
No, I thought it was the opposite. I thought Victoria had actually agreed. The state of Victoria has agreed, if you've been caught up in that data breach, that they will.
They did.
Yes,
they did. Yep.
They will pay for you to get a new licence.
Yes.
So that's actually not strictly speaking true. Then what Vic Roads has said.
Well, how long ago did you ask them, Peter?
About 2 months ago.
It was certainly a change when Optus had their data breach.
That's right.
They certainly came out, and there was an announcement at Vic Roads then.
Right correction. So Vic Roads. So Latitude offered to pay for it. That's fine.
Yes.
Vic Roads introduced another little number that is on the back of your license number, but the actual license number, they refuse to change until you get robbed. You need to provide them with a victim certificate.
Peter, I'll take the question on notice and come back and give you some better detail. I do know that the last time I needed to produce my licence to somebody, they took the number on the back as well as the number on the front.
Okay.
Yep.
You must have a more recent licence than me.
Oh, no, your licence will have a number on the back.
Really, as well? Yeah.
Yes. It's never been taken before.
I'm hanging on to this licence. I look quite nice in a photo. Yeah.
Okay, then it must be fraudulent. Yep. No such thing as a good driver's licence photo.
Oh, I just got burned by David Whiting. Frank in Clayton, good morning. Go ahead.
David, I've got a question which could arise. If you do work at a person's home, in the garden or thing like that, and this person comes to you and doesn't pay you for the work, how can you recover the money?
The least expensive way, Frank, is at VCAT. You issue a claim, a trader dispute, with the person who engaged your services to do the gardening. And you'll be able to represent yourself when you'll pay an application fee, but the current delays at VCAT are horrendous. I was here talking to someone who got a matter listed for November next year. Well, that's a long way out.
How much do you pay at VCAT now for the...
It depends upon the amount that you're seeking to recover.
Oh, yeah, fair enough. Right. Yeah. All right, then.
And when you go to VCAT, you also ask to be paid the fee.
Yeah, fair enough, then. All right, thanks for your trouble.
Thanks, Frank.
That's all right. Thanks for calling in. Tim in Castlemaine, what's happening, Tim?
Hi, David. Yeah, we're getting a renovation done, and we have a window has been ordered. Turns out to be the wrong size because it didn't allow for a lintel above the window, which wasn't drawn in by the architect or noticed by the builder in the structural engineer's report. I'm just wondering, where do we go? Builder has denied responsibility, blames architect. Architect blames builder.
If you look at it, Tim, you'll find there's a hierarchy of documents. So what's happened is the builder has ordered a window that's not the size you want, but is a size that matches the drawings. Is that right?
Correct.
And I think your claim's against the architect for the drawings. There's really a question as to whether the builder has an obligation at law to pick up the mistakes of the architect.
Okay, and so even if they've been given the structural engineer's report as well as the architect, there should be no cross-checking.
Look at the contract and find out what the hierarchy of documents are.
There's just a list of documents that have been supplied as part of the contract.
But there'll be a difference. It depends whether the drawings is in front of the specifications in the hierarchy.
Oh, literally the order of the list.
Yes.
Okay.
And you find which one's got it wrong, and if it's the second one, if it's the one closer to the bottom, I think you're stuck with the specifications.
All right, Tim. Hope that's helpful. Thank you for calling in. Celia in Ballarat. Hi, Celia. How can we help?
Hi, good morning. I just wanted to talk about enduring power of attorney. My mum appointed her brother back in 2005 when you only needed one person.
As a witness, is that right?
No, as a power of attorney.
You still only need one person as a power of attorney.
Well, yes, okay. So what's happened now is, unfortunately, he was so Mum lost capacity last year, and he was appointed as her power of attorney. And unfortunately, now what's happened is that her brother has become incapacitated.
You make an application to VCAT to revoke the power of attorney and appoint someone as your mum's administrator.
I think so. It's been revoked, so we're looking for an immediate thing. But I got some advice last year from a solicitor that said if something happened to him, then the power of attorney would pass equally to me and to my siblings.
Are you named on the power of attorney, Celia?
No.
Then it doesn't pass at all. It stops.
Okay.
It's almost as if the attorney has died, and therefore you need to make an application can't. Mum's lost capacity.
Right.
So you need to make an application to VCAT for the appointment of an administrator.
Okay.
So, and the lists for the guardianship list, which is where administrators are done, is actually quite short. So you go to VCAT and say, Mum's lost capacity, Uncle's lost capacity, we need someone to look after Mum.
But do you...
And you just nominate yourself, is it?
Well, you apply to be the administrator. I went to a guardianship hearing yesterday, and what they do is they say, has anyone else got an interest in what you're doing? So your sister would be involved. If there are other people, it might be your mum's brothers or sisters. Who else has an interest in this?
Okay.
But I would also be talking to your uncle's relatives, because you're going to need to persuade VCAT that your uncle's lost capacity. Because we're now at a point where you go to VCAT, the assumption is that everybody's got capacity. You have to prove the absence. All right?
Okay, thank you very much.
Thanks, Celia.
All right, I think we can fit one more in quickly. David Whiting is with you answering questions, so we'll do an eeny, meeny, miny, mo. Here we go. It's another will question. Ophelia in Box Hill North, go ahead.
Oh, good morning. Thank you, David and Virginia. Just a quick question. My parents have both passed away. They had their wills done in 2000. And what happens, my mother just passed away. Her will has no date on it.
Yes.
So two questions. Does this make the will invalid? And if the will is deemed... Okay. And so what do we do to make it valid?
You need to file a document called an affidavit of due execution. So you need... So where was the will kept?
The will was kept at the solicitor's.
Okay, and so I would be putting the pressure on the solicitor to provide an affidavit as to when the will came into their possession and how and when it was signed. Now, I can give you two examples from personal experience. I signed a person's will on a particular day and he died the following day. I put the day of his death as the date we signed the will. So I had to provide an affidavit to the Supreme Court saying that I attended on this day and we executed the will, we put the wrong date on it, and we got a grant of probate.
Right.
The other one is that every now and then I send a will out to a client to sign and it comes back without a date on it. And if it becomes difficult, it's then difficult to get someone to do it again. We then get one of the witnesses to prepare an affidavit that says, I was present on this day at this time and executed it. So you can overcome it. Your problem is it's 23 years old.
Yes.
Yes, so you'll need an affidavit of due execution that explains the date absence. And that's normally done by one of the witnesses.
Yes, because the witness is still working at the law firm.
Perfect.
But I'm not quite sure, given that we want to get the probate completed, I'm not sure how quick they're going to be to get this done.
I would have thought very quickly. There's no great effort. Yes, that's my signature. I remember that Mary came in on this day and we signed the will, and take it from there.
And we just forgot to put a date on. Ophelia, good on you. Good luck. Nice to see you, David. Thank you so much.
Thank you.
Thank you.